Hello friends, welcome to my channel. I am Rishi Sharma and you are watching Legal Knowledge with Urvashi. In the series of Indian Penal Code 1860, today we are going to look some exceptions in which the accused person may be excused from the consequences of the act. Generally, a person who commit any act know the nature and the consequences of his act and he is responsible for it. Also, it is a duty of the prosecution to prove the person guilt until and unless that person is presumed to be innocent in the eye of law. But the question arises when any person commit any criminal act but without the intention, without the mens rea, then how the law treat them? They can charge that person and punish them, or they can be excused for that offense. The answer of this question is given in Indian Penal Code, Chapter 4, which gives some general exception in which a person can be excused for the commission of any offense. This chapter contains 31 sections from the section 76 to section 106 of IPC. The whole concept is totally based on the legal maxim, which is actus non facet reus nisi mensit rea, which means that the act itself does not make any man guilty unless his intention so. Because the general exception scope is wider, so it is not applicable in Indian Penal Code, but it can be applicable on other special and local laws. And for this, the Section 6 of Indian Penal Code states, throughout this code, every definition of offence shall be understood with subject to the general exception, though those exceptions are not repeated for each definition. The accused can use these general exception if he prove or if he comes under the two grounds. First, they have no mens rea or they have no intention, and secondly, on some other grounds which is recognized by law. Basically, the burden of proof is always on the prosecution to prove that his claim is true and the person commit a crime beyond the reasonable doubt. The term burden of proof means it is a duty of the party who making such claim and he has to prove that the claim is true before the court. The whole concept is basically derived from the maxim which says that the onus of proof lies upon the person who affirms such claim but not who denies it. But under this chapter, the burden of proof is shifted to on the accused person who want to take an advantage of it under this chapter. But he has no need to prove the such excuses beyond the reasonable doubt as the prosecution try to prove. But at the time to prove the accused person trying to prove such claim is true, the court assumed that there is an absence of the circumstances which is given or provided in the general exception. And if the accused person succeed to claim his to prove that the claim is true, this assumption is removed and it is totally upon the court to consider whether such evidence is satisfactory nature or not. And who take advantage under this chapter or not is totally depend on the circumstances and the case itself. Also under the section 105 of Indian Evidence Act, it says that the person accused of offence bear the burden of proving the existence of the circumstances to bring the case within the general exception, and the court shall presume the absence of such circumstances. In this slide, we are discussing the classification of the defense because it is totally based on the person who can't held liable even though commit a crime. The defense is basically divided into the two heads. First is justifiable and second is excusable. Because for committing any wrong, the person must be responsible for doing a wrongful act without having any justification and accuse, and he must have a intention to commit any wrong to any person. If we talk about the justifiable act, it is a such type of act which would be an offense in the normal condition, but there are some circumstances are made up which the act was committed may be a reasonable and acceptable by the court. While the excusable act is a one of the act which the person has caused injury, but he can't be punished and should be excused under this chapter. In this slide, we are looking at the chart of a justifiable general exception and the provision which comes under an excusable general exception and the provision which is come under this. The first one is justifiable general exception. Basically this particular category are deal with those cases or the circumstances under which the offences were committed to furnish the legal justification, and for example, any act which is done by the judge under the direction of law or in the pursuance of the order of the court, or any act which done to prevent the greater harm in the case of the necessity, and in the case of consent, communication, travel act, and private defense. In the case of excusable general exception, this one is basically deal with those cases in which there is a lacking of the mens rea or the intention, such as the mistake of fact, infancy, accident, insanity, and intoxication. We'll look into all these provision one by one, but in today's video, we only look at the one provision, that is mistake of fact. But before, please like, share and subscribe my channel for more related videos. As we discussed in the previous slide about the defenses, types of defenses and the provision which comes under it, in this slide we are discuss the some provisions of excusable exception. The first one is mistake of fact, which is come under section 76 and 79. But before going through this provision, we have to understand, because all of us have a question about what is mistake in law. So guys, the mistake is a act which is done by a person mistakenly or unintentionally, which constitute a injury or the damage to another person. Importantly, the mistake is not a pre-planned act or a pre-arranged act. It must be a the act done by the mischance. Then it comes under the mistake. Now, what is a mistake of fact, which is defined in section 76 and 79? So, the section 76 of IPC says that nothing is an offense which is done by a person who is or who by a reason of mistake of fact and not a mistake of law, in a good faith, believe himself to be bound by law to do that act. It means that a person commit any criminal act in the good faith and ignorance of the material fact, whether they can't foresee it or they're not intended to do know the unlawful consequences and they commit it. In short, any act which is done by the mistake of fact and not a mistake of law, but done in the good faith and he believes that he is bound by law, then he is not punishable in the law. This whole concept is based on one maxim, which is ignorantia facet dot excusat, ignorantia juris non excusat, which means that ignorance of fact is excusable, but ignorance of law is not excusable in law, and the act which is done must be the ignorance of fact and not the ignorance of law. This whole concept or whole principle is based on the ground that they always done any act in the public policy and the judicial expediency. Because if such type of ignorance of law become excusable, then it is impossible for the prosecution to prove wrong, and the person such as accused may misuse it as a defense. For example, suppose the A is a soldier and he fired on the mob by the order of his superior officer. In the conformity of that order within the command of the law, has committed no offense because he is protected under section 76 of Indian Penal Code 1830. But it is important that such order or such command must be a lawful, and if that command is unlawful, then the person is not protected or not excused in this section. Moving forward to section 79 of Indian Penal Code 1860, it talks about any act done by a person who is justified in law or by the mistake of fact believing himself that he is justified by law. It means that any act which is done by any person in a good faith under the mistake of fact and it not a mistake of law, and he believed that that act is justified by law to do that act, that he can be excused in this section. For example, suppose A is in a good faith believe that A commit a murder, and he sees him and arrested by the proper authority on that information. Though the Z was acting in the self-defense and not a murderer, but A can't be commit any. Also, the A can't be commit any offense because he thought in the good faith on the reasonable ground that he was justified by law to do that act in the favor of the society. In both sections, section 76 and 79, we all talk about the mistake, which is mistake of fact and not a mistake of law. So what that means? How can we differentiate about the such act is a mistake of fact and not a mistake of law? So there is a maxim which is talk about that, or give a differentiate differentiate the both the terms. There is a maxim which is ignorantia facit dot excusat, ignorantia juris non excusat, which means that ignorance of fact is excusable and ignorance of law is not excusable. And the whole concept is based on the public policy and the judicial expediency. It means that if any person done any act which is against the law, so it can't be excused, or if it can be excused by law, it is a possibility that the accused may misuse it as a defense, and it is impossible for the prosecution also to prove the guilt of the accused person. So there's a presumption always that everyone know the law of land, and they behave accordingly. Suppose some person says that I don't know the law, and because I don't know, I did the offense. So it is not excusable in law. Also, it is applicable on all the person, irrespective of it is a citizen of the country or he is a foreigner, or even the new law. Even the new law is passed by the legislature. It is believed or it is presumed that everyone know that law also. I hope now you understand the concept of general exception and this provision of section 76 and 79. Thanks for watching. Please like, share and subscribe my channel for more videos.